Hello all. In this video, I will offer my take on the move by the Kerala state government to challenge the Citizenship Amendment Act and its constitutional validity under Article 131 of the Indian Constitution. You would all know that this comes after numerous petitions, in fact, around 140 odd petitions that have already been filed under Article 32, uh, challenging the CAA for its violation of certain fundamental rights like Articles 14 and Articles 14 and 25, which talks about the right to equality and the right to practice and propagate religion. In fact, day before yesterday, the hearings in those Article 32 petitions have, to sort of say, officially kick-started, even though nothing substantial took place then. So, in the suit filed in the Supreme Court, the Kerala government has also argued that the CAA violates the principle of secularism and the fundamental rights like Articles 14, the right to equality, and Articles 21, the right to life, and Articles 25, the right to religion of the concerned individuals. Now, before we proceed further, let us quickly underline what Article 131 intends to do or what it states. It states that the Supreme Court shall have the original jurisdiction or original and exclusive jurisdiction in a dispute between the government of India and the state governments or between two state governments regarding any question on which the existence or the extent of a legal right depends. Now, to decide whether the Kerala government could have filed a suit under Article 131 to challenge the constitutionality of the CAA for violation of fundamental rights of individual persons, we need to address two specific questions. First, whether laws can be parliamentary laws or laws passed by any legislative body in India, can they be challenged as being unconstitutional? And if found to be so, can they be struck down by the Supreme Court under Article 131 proceedings? This is the first question. Second question is, if yes, then what kind of statutes or legislations can be challenged in such a manner under Article 131? Or to put it in other words, what kind of disputes can you bring under its ambit? Now, the answer to the first question is, I believe, quite straightforward. Because starting from the 1960s till the end of this decade, several judgments of the Supreme Court have categorically clarified that constitutional validity of legislations can be tested under Article 131. And if found to be unconstitutional, they could be struck down as an invalid law. I will highlight three major cases as examples in this regard. The first major case under Article 131 was in the year 1963. This was in the case of State of West Bengal versus Union of India, in which the Supreme Court entertained a suit under Article 131, which challenged the validity of the Coal Bearing Areas Act of 1957, passed by the Parliament. The ground on which it was challenged was that this law is unconstitutional because the Parliament did not have the legislative competence to pass such a law under the 7th schedule of the Constitution regarding acquisition of coal fields in a particular state. Now, this was directly challenging the legislative competence, which is one of the critical aspect of the federal scheme of things in India. In this case, ultimately, even though the court upheld this law, saying that the parliament had the legislative competence, it assessed its constitutional validity So the takeaway is that the constitutional validity of a law can be allowed to be tested under Article 131. Later in 1977 as well, a seven-judge bench of the Supreme Court, in I would say, a categorically important decision in state of Karnataka versus Union of India, it also similarly entertained an Article 131 suit filed by the Karnataka government, which challenged the validity of Section 3, if I'm correct, of the Commission of Inquiry Act 1952. Uh, Later in the video, we will discuss this judgment in some more detail. So keep this judgment in mind: State of Karnataka versus Union of India, 1977 Supreme Court. Third example would be, I think, a more authoritative and, in fact, a more recent case. Let us talk about the Supreme Court's Constitution Bench decision in State of Tamil Nadu versus State of Kerala, famously known as the Mullaperiyar Dam judgment. In this case, which was finally decided by the Supreme Court in May 2014, Tamil Nadu had challenged the validity of the Kerala Irrigation and Water Conservation Amendment Act of 2006, passed by the Kerala Legislative Assembly. To give you a brief idea, this law restricted Tamil Nadu's right to increase the water level of the Mullaperiyar Dam, which is on the Kerala and Tamil Nadu border, from which water is used by both the states. In this judgment, the Supreme Court held that law to be unconstitutional for the concerned reasons. So, these three examples sort of might signal a bell of clarity that yes, therefore, the Kerala government cannot be found wrong in challenging the constitutionality of the CAA by filing a 131 suit, because the SC has allowed it in the past in these three cases that we saw as examples. However, we must carefully analyze the second question, that is, what kind of statutes can be challenged in this manner under Article 131, or what kind of disputes, what is the nature of those disputes that you can bring under its ambit, under the ambit of Article 131. Only after analyzing the second question can we sort of find a more conclusive answer to whether the Kerala government could have challenged the CAA for violation of fundamental rights of individuals, like it did in the last week or so. To answer the second question, let us first identify the nature of Article 131. So, a plain look at its text itself will show to us that it is about disputes between governments at both levels of our federal system, both at the center as well as in the states. Now, why did the Constitution envisage the need for having a provision like Article 131? It is simply because in a governance system that is, I would say, largely federal, I would not call India a purely federal country. So, in a governance system that is largely federal with different tiers of governments with different set of powers and at different hierarchies, disputes are bound to happen regarding, let's say, for example, division of and encroachment upon each other's legislative powers. It could be about conflict in determining the executive powers of each government in the implementation of laws. It could also be about distribution of resources, be it financial resources or be it natural resources, like we see in the Mullaperiyar case. It could be about validity of state reorganizations that happen territorially, like it happened, let's say, in Telangana and Andhra Pradesh, like it happened in Jharkhand and Bihar. It could also be about arbitrary dissolution of state assemblies or imposition of presidential rule in a state, etc., etc., etc. Now, these are all constitutional disputes that affect the federal character of the constitution and the governance system. It also affects the balance of hierarchies in our federal system. In such a situation, there needed to be a final arbiter. Now, there were discussions in the Constituent Assembly of India when it was drafting the constitution, specifically on June 3rd, 1949, regarding this particular provision, Article 131. In the draft constitution, the present day Article 131 was termed as Article 109, for your information. Now, in that debate, some argued that when there is a dispute between the central government and the state government, or even between any two state governments, the final say must lie with the central government. The logic provided was that state governments are essentially subordinate in this, should be subordinate. Now, this was suggested by Mr. Brajeshwar Prasad, who was a member of the Indian National Congress at that time. And in fact, he was in favor of a unitary style of government rather than a largely federal setup. So, however, this was rejected by the assembly as it did not want an over powerful central government to sort of dilute the established federal setup of India. I mean, this is seemingly legitimate for obvious reasons because political and electoral scenarios can impact the neutrality of such dispute resolutions if it is handed over exclusively to the to members of the central government executive. Right? Now, thus, the authority in such disputes was handed over to the Supreme Court. The Supreme Court's Mullaperiyar judgment, which we mentioned earlier, in its paragraph 152 as well, sort of substantiates this basis of Article 131's place in the Indian Constitution. Now, evidently, Article 131 sort of stands out from all other kinds of jurisdiction the Supreme Court possesses, which are mostly to deal with regular cases concerning citizens and their rights vis-a-vis other individuals, vis-a-vis the society and the state as well. As we proceed, this nature of Article 131 needs to be kept in our minds, right? Now, from here, if we go on to look at the cases that have been decided under Article 131, this nature of Article 131 to decide disputes involving a federal question will become clearer. This is where I want to take your attention back to that judgment we had mentioned earlier, the 7-judge bench decision of the Supreme Court in State of Karnataka versus Union of India. In this case, speaking through the majority judgment by the then Chief Justice of India, Sri M.H. Beg, the majority judgment in paragraph 146, paragraph 146 of the judgment's SCC copy, by the way, traced the historical origin of Article 131 back to Section 204 of the Government of India Act 1935, which had a similar sort of a provision authorizing the erstwhile Federal Court of India to settle such government-to-government disputes. Now, the majority judgment held that this original jurisdiction is a critical feature of the Indian Constitution so as to ensure an equitable balance in the division of state powers between the federal units of the Indian state. Even Justice P.N. Bhagwati's concurring judgment in its paragraph 201 and the concurring judgment of Justice Chandrachud in paragraph 164 as well. Both these judges also agreed that this particular article, Article 131, is a necessary concomitant of a federal or a quasi-federal form of government. So if you observe the tone with which Article 131 is talked about in this judgment, as well as in the assembly, in the Constituent Assembly, it indicates the unique or the limited nature of Article 131, purely to deal with federal questions of law and fact. On this basis, of the nature of Article 131, the majority judgment of Justice Beg, again in paragraph 146 itself, states that for an Article 131 suit to be successfully entertained, the states must show that it differs with another state or the union government on a question of interpretation of the constitution, so that a decision of it will affect the scope or exercise of governmental powers which are attributes of a state. Now, I read it out verbatim from the judgment. It's important to highlight the focus on the nature of the dispute should be in the manner that it ought to have an impact on the governmental powers of either the union or the state government. The concurring judgment of Justice P.N. Bhagwati is also critical regarding the maintainability of an Article 131 suit. Bhagwati also held in paragraph 204 that the legal right in the dispute raised must be of the plaintiff government or of the defendant government. This clarifies clearly and underlines the fact that the legal right mentioned under Article 131, which we sort of looked at in the beginning, should be of the government parties that are parties to the dispute. Unfortunately, I cannot share a copy of the SEC copy of the judgment, but I'll definitely attach the Indian Kanun copy of the judgment in the description below. I request all of you to go through the mentioned paragraphs at least, if not the entire judgment, so that you get a better sense of what we discussed till now. So, thus, the keeping in the discussion still now in mind, it has to be concluded that the effect of a challenged legislation under Article 131, the effect of it on the legal rights of the government must be in the nature of a federal issue, and that's a very important question before a Article 131 petition, Article 131 suit is entertained by the Supreme Court. If the legal rights of the plaintiff state or the defendant government have been affected, the suit would definitely be maintainable. Underline that fact. Also, this very nature of Article 131 proceedings, as we saw in the historical discussions as well as in the case law discussion, this nature of Article 131 can be further clarified if we take a brief look at the past cases that have been instituted under 131. In fact, only a very limited number of cases have arisen under 131 till date, which sort of also goes on to indicate the limited ambit of when Article 131 can be invoked. Thanks to live law, they have listed out some of the major cases that have arisen under Article 131 with a brief summary of each case. I will provide a link to that article in live law in the description below. However, to mention briefly what are some of those cases. In 2011, in this case of state of Madhya Pradesh versus Union of India, here the government of Madhya Pradesh had challenged the constitutional validity of the provisions under the Madhya Pradesh Reorganization Act of 2000, which split the resources of the electricity boards of Madhya Pradesh and Chhattisgarh following the bifurcation of the undivided state of Madhya Pradesh, on the ground that there were no guidelines which sort of regulated the way in which the central government could sort of divide and apportion the assets and liabilities of these electricity boards of the new states. Similarly, in 2014, there was the State of Jharkhand versus State of Bihar case, where Jharkhand had similarly filed a suit under Article 131 challenging the validity of the Bihar Reorganization Act of 2000, which again similarly dealt with the apportionment of pensionary liabilities of former employees of the original state of Bihar. Going back to some of the cases that we already mentioned in this video, State of West Bengal versus Union of India 1963 decision dealt with conflict between the state and the center regarding the legislative competence under the 7th schedule of the Indian Constitution. Mind you, the Coal Bearing Coal Bearing Areas Act of 1957 was not challenged by the state of West Bengal for violation of any fundamental rights under Part 3 of individual citizens or persons. Rather, it challenged it for a reason concerning the federal nature. Even the heavily discussed State of Karnataka versus Union of India in 1977, the challenge was against the excessive powers, so to say, of the central government under the parliamentary law to constitute a commission of inquiry against a sitting chief minister of a state. Also, the Mullaperiyar judgment, if you consider, it was about distribution of riparian rights and natural resources to two states that territorially shared the same river or the dam. Now, the common trend in all these cases, sort of cutting across all these cases, is the existence of a federal aspect in the dispute between the concerned governments. So, note that under Article 131, disputes ought not to be about differences between the governments in the interpretation of any random aspects of the Constitution or of the fundamental rights concerning citizen rights, concerning the citizens. But as Justice M.H. Baig sort of stated, Article 131 is to deal with disputes between governments about the interpretation of the scope of governmental powers allotted to each other under the Constitution or, for that matter, under any other laws. Now, a quick glance at the copy of the suit filed by the Kerala government will indicate that their challenge against the CAA clearly does not come under such an ambit of Article 131. Why do I say that? As mentioned in the beginning itself, Kerala's challenge is based on violation of the principle of secularism and fundamental rights of the concerned individuals under Articles 14, 21 and 25 of the Indian Constitution. Mind you, a challenge to constitutionality of the CAA for violation of fundamental rights of the individuals who are going to be affected does not really fall within the category of disputes that have, any bearing on the federal relationship between the parliament and the legislative assembly of the state or the central government and the state governments. Moreover, let me again remind you that the Supreme Court in 1977, Karnataka versus Union of India, had stated that legal rights which are in the dispute under Article 131 ought to be of the concerned state or central governments. Interestingly, if you go deeper into the suit filed by Kerala government, it argues that if the CAA is allowed to be implemented, the state will be compelled to implement a law which it believes to be arbitrary and unconstitutional. Now, this is the only link that the state draws to connect this plea to Article 131. Now, how can this argument said to be an issue that questions the existence of a legal right of the plaintiff state in a way that it touches upon the federal character of the Constitution? As seen in part 2 of this video series on CAA, Articles 256, 257, 258 or even for that matter 365 of the Indian Constitution forms a code which sort of mandates state governments to implement every union law regardless of their disagreements with it. Now, this is a constitutionally allowed mechanism that has no effect on the state government's rights. Now, it is not a coercive compulsion, rather, it is a part of the constitution's federal scheme of things. I would request you to kindly watch part 2 of this video series in order to get a better idea of this area of the discussion. Moving further, in we are, in entertaining a suit under Article 131, we ought to look at whether the CAA in it, in terms of its contents, in terms of its merits, in terms of its substance, and in terms of its impact, does that have an impact on the federal structure? This is what we have to look at. And by the way, it does not have it. The CAA, or the way in which it was passed in the parliament, does not in any way affect the legal rights of the Kerala state government. So, in conclusion, I am of the view that the suit filed by Kerala under Article 131 should not be entertained by the Supreme Court. And I think it would be right to put that yes, there is no blanket ban on states to invoke Article 131 to challenge constitutional validity of statutes. However, the only limitation should be with respect to the nature of the dispute or the issues raised in that suit. It should be of a federal character. To highlight sort of what could be, to end this video, to highlight what could be permissible under Article 131, I think a recent example itself will show us that. Immediately after Kerala's suit under 131, Chhattisgarh state also filed a suit under Article 131, not challenging the CAA but challenging the National Investigation Agency Act of 2008. The grounds for Chhattisgarh to challenge the NIA Act of 2008 was purely federal in nature. Their argument was based on the fact that the parliament did not have the competency to pass a law that overrides the authority of the state police and the state government. Why? Because policing is subject matter that falls under the state list in the 7th schedule, over which the parliament has no legislative competence. Thus, the argument sort of revolves around the fact that this affects this law, NIA Act of 2008, affects the balance of the division of federal powers to enact legislations under the constitution. Now, this is the kind of disputes that should be entertained under Article 131. Now, if you compare this with the suit by Kerala, you would see that stark difference. For your benefit, I will attach a copy of both these suits in the description below. So that's all from my side. Thank you so much for listening to these long videos. I'm sorry for the length of these videos, but I believe the content is so much that it deserves to be given full and detailed attention. Thank you.